Good morning, everyone. Welcome. Our first case for argument this morning is Michelle Slyke versus Village of Howard. Mr. Weininger.
Thank you, Your Honor. May it please the Court, Andrew Weininger of Eminent Domain Services, LLC in Madison, Wisconsin, for the plaintiff's appellants. Present at council table is my colleague, Sarah Olson, and also present is Leland Hill, Michael Truckee, Amy Truckee, Michelle Sleek, and Frank Sleek. Deb Fry wanted to be here as well, but she's the caregiver for her adult child. In this case, the district court erred in three ways. First, the court analyzed the special assessments as an obligation to pay money and not as a Fifth Amendment taking. Second, the court dismissed appellant's procedural and substantive due process claims on the uncertain assumption that state law remedies are definitely available to appellants. And third, the court ignored the specific examples of benefited property owners that appellants identified to support their equal protection claim. I'll start by addressing our takings claim. Since at least Norwood, there's three prongs that have to be satisfied for a special assessment to be legal. It has to be local, a local project, not a general project. It has to confer a special benefit on the property that the municipality seeks to special assess, a special benefit. And that's an uncommon advantage to the property. And third, it has to be reasonable. And what that means, it has to be proportional. The amount of the special assessment has to be proportional to the special benefit accrued to the property.
That argument all assumes that Norwood laid down some general principles for takings law, and I'm not sure that's the takeaway from that case after the Supreme Court's many decisions in the immediate aftermath of Norwood demonstrate that the decision was really very narrowly related to its facts, and in fact there are decisions from the court saying that it should be understood that way, and then it not having been cited in any takings jurisprudence since the New Deal. I mean, it's a pretty crusty old case that you've rested your entire takings claim on.
There have been examples of courts relying on Norwood. CED Properties case from Wisconsin found that a taking in substantial excess of the special benefit based on Norwood is a taking. There's a South Dakota case that discusses Norwood extensively. The cases that Your Honor is referring to, I believe, are Webster, Cass Farm, Parker, Tonawanda, and French. Those are the turn-of-the-century paving cases. And in those cases, the challenge to the special assessment was the how it was calculated using the front foot methodology. There wasn't, the claim in those cases was not that the special assessment was in substantial excess to the amount of the special benefit, because what happens is if the idea...
I'm not talking about the specifics of what was at issue in that entire line of cases. What I'm talking about is the court's language saying, don't overread Norwood. And Justice Harlan was really up in arms about that very clearly. He was the author of Norwood, and he objected in several dissents in the early 20th century, objecting that his colleagues were misreading Norwood and were undermining it by subsequent cases. But we have to take the majority at its word that Norwood was really kind of a one-off. That word wasn't used back then, but that's basically what the court was saying. Don't overread this. It was a unique situation where the property owner had property taken. There was a condemnation. The jury set his just compensation for the taking at $2,000, and then the municipality came back and adopted an ordinance assessing him for that $2,000 plus a whole bunch of other costs. And the court said that's kind of like a due process violation, equal protection violation in the sense of class of one. That's how we refer to it today. That term, again, wasn't used back then, but that's essentially what the court's decision rested on. It wasn't really announcing any new principles of takings jurisprudence, and to the extent that there are some state courts who interpret it that way, that's probably wrong, and we don't have to follow that.
My reading of Norwood is that it's a factual determination, and the facts in Norwood supported the finding that assessment in substantial excess to the benefit is a taking. So it's not a blanket, what Norwood does make clear is not that all special assessments are illegal, or it's just that the government's power to special assess is not unlimited, and that Norwood observes that private property rights would be seriously impaired if landowners were barred from challenging special assessments, and the line between a taxation and between a taking is the substantial excess, and that's what the factual finding for the court to make. And that's the case that we proved here, was that there was no benefit to the property, and these properties were assessed tens of thousands of dollars. There was no benefit to the property. The project itself wasn't local. The project was for the general community and to spur development in the community, and it just so happened that the plaintiff's appellants were living adjacent to the road and received just the same benefit that the general public did. They received no specific benefit to their properties, and in fact their properties were made worse. So the village itself could have made the case that the properties were specially benefited, that they increased in value, and they didn't make that. They put forth no facts in this case that there was an increase in value to the properties as a result of the special assessment. And the principle underlying it is that for a special assessment to be valid, the idea is if it goes up by $2,000 because of this special benefit to this property as a result of the local project, then the special assessment roughly matches. It doesn't have to be equal, but it roughly matches. So a $2,000 improvement and a $2,000 assessment, it's roughly equal. What we had happen here was no benefit, or the properties were made worse. So for Hill, for example, that property was made worse. It was assessed tens of thousands of dollars. The village itself admits that it's too expensive and arduous for Hill's property to connect to the water and sewer, and so he's been charged tens of thousands of dollars for this assessment for no benefit. So the taking is...
It seems like a stretch to say no benefit here, given the hooking up to the sanitary sewer and the storm sewer system. To say no benefit, it seems like a stretch.
And that's our position. We've set forth, I believe, a lot of facts that this was to benefit the general community, that it had to be...
But your client's property is now hooked up to the sanitary sewer system and the storm system. So there may be benefits to others and to the community as well, but to say that your clients didn't receive any benefit seems a stretch.
They had there's a lateral that they can then pay additional sums of money to connect to, so their properties aren't connected. Their sewer and water were totally fine, so that there was no benefit, and we set forth expert opinions and facts that didn't benefit the property. The village, on the other hand, didn't set forth any facts. They just said the benefit is the lateral, the benefit is the road. That's not a benefit. There has to be some type of an analysis or proof that this is a specific special benefit to the individual properties, and it has to be different in kind, not just in degree. So the village has taken this position. Well, we put in a larger water main, but in essence we charge the clients less. The special benefit has to be unique to the property and a unique benefit, and quite clearly this project would have been designed irregardless of my clients living there. This project was to accommodate a change to the interstate system and how traffic flowed. It was designed...
But why does that matter? If your clients were living there or not, if they got the benefit to the property?
The first step in the special assessment process is to look at the project and determine whether or not it's a local project or a general project. If it's a general project, the analysis ends and it cannot be a special assessment. It has to be.
And what's the legal source for that rule?
It's Norwood, it's Wisconsin law under CED, that it's a three-pronged process, and that's set forth.
But we wouldn't be applying Wisconsin law in a federal takings, Fifth Amendment takings claim.
Well, this was brought in state court. It was then...
I understand, but it's a federal cause of action. It's based on federal takings.
There's grounds for it.
And the Supreme Court said about Norwood that it wasn't meant to essentially make every state case a 14th Amendment case or a takings case. Not in Norwood, but cases subsequent to Norwood where they've interpreted Norwood.
Norwood sets forth clearly that it has to be local. It has to be.
So just to make clear, your 3 prongs that you're giving us are really based on Norwood only
I think.
and state law.
Both, yes.
Okay.
Let me ask you this: if we set to one side your Norwood argument, which you've made quite clear, and you are talking to us about the facts you put into the record, your position is the village did not put in other persuasive or contrary facts. Are we then left with you asking us to be weighers of finders of fact and make a contrary decision that the village itself did not weigh and that the state court itself could sort out if this case were back in state court?
I think I think there is sufficient facts that we've set forth in summary judgment to support a finding of judgment in favor of the plaintiff's appellants, and certainly we would ask the court to do that. Otherwise, I think that the court should overturn the district court's decision regarding the constitutional claims, because with regards to the takings claim, certainly we've set forth a taking here in the court.
But if we set that to one side,
and then we have the procedural due process and substantive due process, and the equal protection. The substantive due process and the procedural due process were dismissed by the district court on the basis that there was undoubtedly state court remedies available, and that is somewhat in dispute because in moving for summary judgment, the village raised for the first time that our state claims were untimely filed, and I would submit to the court we did timely file them, and to the extent we didn't timely file them, we would have a ripe procedural due process claim, because for the first time moving for summary judgment, the village claimed we're actually going under a village ordinance. That village ordinance was never once mentioned in any of the filings or any of the proceedings that led to the special assessment, and in fact they had followed Chapter 66 0703, that procedure, in sending a preliminary resolution, and the final resolution in this case didn't mention any ordinance. It in fact didn't mention any state statute. It was just.
Is there anything pending in state court now? I know there were 2 suits filed and they were removed to federal court, but do you also have a claim in state court challenging the assessment?
It's the state claims were brought. This entire case was brought in state court. It was all then
Correct.
removed.
But is there anything still pending in state court?
The state claims, I believe.
You didn't
part of
file
it.
a separate.
No.
Have you filed anything separate
No.
in state court challenging the assessments themselves?
No. The challenge to the
Okay.
assessments was this
So the
lawsuit.
only cases now pending pertaining to this are the 2 that have been consolidated in federal
Correct.
court.
Yes, and that was done because 66.0703, the state claim, says that all claims have to be brought at the time, and we didn't want to be precluded. So with that, I will reserve my remaining time for
That's
for
fine, thank you. Ms. Tierney.
Good morning, Danielle Tierney for defendants appellants. I want to pick up and correct a couple of factual misstatements that were just made. To answer your question, Judge Saini, there are, after the summary judgment decision, the state court cases or state court claims were dismissed. They were remanded back to the 2 original circuit court cases. We did have 2 status conferences where plaintiff's counsel had asked that the cases just kind of linger while this gets resolved. So the 2 cases are pending currently.
But nothing, they're stayed essentially until
They are not officially stayed, they are unofficially stayed, but the claims are pending.
Okay.
In the same circuit court?
In the same circuit court, but they were 2 different cases. So there were 2 state court cases filed. They were then removed to federal court and then consolidated. So when the district court dismissed the claims, they went back to the 2 separate state court cases. Secondly, I want to address the
And do you,
statute.
I'm sorry, just one more question. Do you plan to argue, if it stays in state court, that the claims are untimely?
Yes, that was a defense that was raised.
Why wouldn't that deprive them of a state court route?
We did cite law in our brief that an untimely appeal, an untimely exercise of a procedure that's available does not render that appellant or that plaintiff's procedures unavailable as a matter of law that would give rise to a due process claim. Otherwise, anybody could just waive an appeal deadline and then run off to federal court and say, well, my procedural due process rights were violated, and that's just not the law.
The
So-
remedies exist on the books if they were,
I'm sorry?
the remedies exist on the statute books.
Correct, and they are available for somebody to avail themselves of.
And to be clear, you haven't won on that. That's something you just plan to raise, and the state court will have to make an independent
Correct,
ruling on
correct.
that.
And that brings me to this issue of local versus special versus general benefits. I think that's a little bit of a misstatement about what's before this court. That's an issue related to the state court cases. So one of the issues that the appellants and that the village have been disputing is under what authority the special assessments were made. We outlined in our statement of the case, specifically, I can draw your attention to one of the footnotes, footnote 3, 4, and 5 of our brief, which is document 13. It highlights some of the language that was used in the notices and the agenda items. There's been a representation that the village never told any of the homeowners and property owners under what authority they were acting. All of the ordinance or all of the resolutions, agenda items all point to that the village was acting under 66.0701. And that's where this discrepancy comes in between the local benefits versus a special benefit versus a general benefit. But as it pertains to the federal claims pending before this court, that really doesn't matter. The question is whether or not there was a Fifth Amendment takings, whether or not there was a due process violation, and whether or not there was an equal protection violation.
I think his counsel's argument is that it matters under Norwood when looking at the substantial excess.
And
That's what I understood it to be.
And I question that because I've read Norwood many times in preparation for today's argument, and I haven't seen anything with respect to this local versus special versus general. And in fact, this three-pronged test that they keep referring to is from a Wisconsin state case, which I would also note the Wisconsin state case didn't discuss any of the cases subsequent to Norwood. And I would also note with respect to the representation of the numerous cases in maybe not this century, but at least the last century, all of the state court cases that were cited on appellant's brief, page 17, the South Dakota case, the Nevada case, the Texas case, so on and so forth. I did look up all of those cases. Not one of those cases discussed a single Supreme Court case after Norwood. So there was no mention of the French case. There was no subsequent clarification.
Since you have read Norwood and its progeny so many times, what is your understanding about when a special assessment, at what point it can constitute a taking under Norwood and its progeny?
Certainly. And I've been thinking about this, trying to distill that, and the closest thing I can come to is kind of the pornography definition. The court will know it when it sees it. Norwood and its progenies have established that it needs to be this egregious and obvious. I think the language that certain cases have used is patent, patent abuse or patently obvious. But this idea that federal courts need to step in on local government assessments and weigh this equal benefit, 2,000 to 2,000, 2,500 to 2,500, that's exactly what the Norwood subsequent cases said federal courts should not be doing. Otherwise, federal courts are going to get pulled in on every assessment challenge. And I don't know, I could have, but admittedly didn't look up when tax assessment challenge statutes kind of came into existence and whether or not that had any reasons for why we haven't seen any cases under Norwood or special assessment challenges since really the early 1900s.
Well, it probably has something to do with the fact that the Supreme Court has said fairly unequivocally that taxes are not takings.
That also bears into it, but I think that goes into.
And that the idea of due process was very different in the late 1800s, early 1900s, and has undergone a doctrinal shift of some significance since the New Deal.
Correct. And the court's saying, we're not going to get involved. You have procedures available. You have the opportunity to challenge this. You have the opportunity to go in and say, my assessment's too much. And that kind of segues into their due process claim. Let's assume for the sake of this discussion that they did timely file it. Obviously, that will be something for the state court to resolve, whether or not their appeal was timely. But the state court affords them, or will afford them, could afford them, the remedy that they're seeking. They're arguing either that they shouldn't be assessed at all because they say they have no benefits, and they can make that argument to the state court. And if the state court buys that argument, the state court can modify, the state court can affirm, the state court can completely remove their assessment, so they get what they're looking for through the state court process.
Well,
And that's actually, I'm sorry, that's actually all that the Norwood majority said, which was that the property owner in that case was deprived of an opportunity to challenge this assessment.
Correct.
And that was a violation of his property rights. And the later opinions from the Supreme Court suggest that that was essentially a due process holding and perhaps an equal protection holding rather than an announcement of a takings law principle.
Correct. And I'd also like to note, so I know these are obviously not binding on the court, but the appellants did cite to a couple of cases from the Fourth and Fifth Circuit from about, I think, 1920s and 1930s, and said, well, these more contemporary cases, although I don't know, 90 years is really contemporary, but these more contemporary cases support our position that Norwood is good law. And in those cases, they were not necessarily inconsistent with what the subsequent cases after Norwood said, which is if we're looking at some seriously egregious facts and that landowner is denied the opportunity to kind of present their case as to why this is an unfair assessment, then that might give rise to a due process violation.
You aren't disputing that Norwood is still good law. You're just disputing what it stands for. The Supreme Court hasn't overruled it. They cited it last year in the de Villiers case. I don't think we could say it's overruled, but what it stands for is, it may not be as broad as what's been articulated here.
Correct. There's been no court that's explicitly overruled Norwood, but the subsequent cases have pretty explicitly identified that it's a very narrow
Habited,
case.
yeah.
Yes, and it's limited to kind of those egregious facts, which is we took your property and then we assessed you for it, and then on top of that, we also assessed you our court costs.
Let me ask you this. I hear much of your argument is this is hyper-local and, this is state court matter. Why then remove it? And although why then remove it? And then also, why lean into plaintiffs' constitutional arguments and win below and then come here and ask us to construe the doctrine of constitutional avoidance in the way you have, which and you leaned into that.
Certainly. Well, with regards to the removal, I can say from our firm's practice, we like to remove any cases that have any kind of federal claims to them just because we think the federal courts tend to be the best arbiters of federal law. And with respect to the doctrine of constitutional avoidance, admittedly, that was perhaps developed a little bit later in the case. I can attest that I came into this case a little bit later. The issue was raised during summary judgment, and having been a participant in the St. Augustine case where this panel, during the course of its litigation, noted the issues or the potential implication of constitutional avoidance, admittedly, I think this is just a case where it should be applied.
And how would that work in this case?
So in this case, so the doctrine of constitutional avoidance, as I understand, is that anytime a court or a federal court is tasked with deciding federal issues, but if there are related state or relief under state law that could afford the same remedies and give the applicant or the plaintiff their relief that they seek, that the court should not that the court should first look to see whether or not state law would provide that relief before they address any of the constitutional claims.
Well, that's just an order of battle question. You're not suggesting that the plaintiff should win on the state law claims.
No.
And that's the only way we would apply constitutional avoidance. In other words, if the plaintiffs can get all the relief that they're asking for under a state law claim, there's no reason to reach a federal constitutional question because that's essentially an advisory opinion. That's all that the St. Augustine case stands for, because the plaintiffs in that case won their state law claim after the interpretive question involving Wisconsin law was certified to the state Supreme Court.
Well, I think if they, I guess the issue of constitutional avoidance is a little collateral because the procedural due process claim, regardless of if they win or not at state court, the existence of state court or relief in the state court and through the state proceedings kind of nullifies their procedural due process claim. And then with respect to their takings claim, I suppose this is more appropriately argued to the procedural due process aspect because our argument on the takings claim is they don't have a takings claim. There's no taking of property. There is an assessment of money, which the Supreme Court has repeatedly, unequivocally, and indisputably held on numerous occasions is not a taking. I'd note in appellant's reply brief, when addressing our argument regarding taxes as takings, the appellants do not dispute that taxes aren't takings. They also don't dispute that special assessments are taxes. And so I think that's pretty dispositive of the entire argument. And instead,
The district court relied on a line of cases involving order to pay cases, which seems a little bit off because those cases are more general obligations that aren't tied to specific property, whereas the tax cases are tied to specific property. It seems like that would be the better analogy here than just these general order to pay.
And admittedly, there aren't a lot of cases where there are tax assessments. We've got this.
I think that's in part probably because of the exhaustion requirement that was in place for a century until the Supreme Court in the Nick case undid the exhaustion requirement. So that could be why we don't have any case law
Fair.
here. But it doesn't seem like the order to pay, that's the best analogy to what we're talking about here, which is some form of a special assessment, some form in some way connected to the property, where the order to pay cases are not.
Certainly, and I think in that, because there are no Supreme Court cases on that issue, this court could look to some of the other circuits' decisions that we did cite in our brief on, I'm looking at page 21, the Eighth Circuit case, the Federal Circuit case, that discuss special assessments in that scenario. Additionally, this court did affirm an Eastern District of Wisconsin case that mentioned how if an appellant's argument were taken to its logical end, any taxpayer or filing of fees would have such a claim, and the Constitution does not prohibit the government from taking money in the payment of legitimate fees or levies. So based on the analysis, I think the court can apply that and come to the conclusion that this is a tax, not a taking, and should affirm the district court ruling. Thank you.
Thank you. Mr. Weininger.
Listening to the village, it sounds that they agree that under egregious facts, there is a Norwood taking, and I would submit to this court that there are a lot of egregious facts in this case. Mr. Hill was assessed $37,000 for water and sewer that he can't hook up to. The village designed the project to make 80 acres that they own eminently more valuable so they could build a sports complex. And the village itself has admitted that for all the properties, it didn't raise the monetary value or the non-monetary value of their property. So I'd submit that these are egregious facts, and in this case, the district court didn't analyze those facts, and it's a factual analysis for the court to undertake. The two cases that, respectfully, I don't think it's as clear-cut, the limitations that were set on Norwood. I really believe that the turn-of-the-century cases regarding paving had to do with the front foot assessment challenge, not that these were some egregious facts, very likely because they were a nominal amount of money for a nominal benefit and it matched. And so the challenge was to the front foot assessment. The Town of Clover case, which was just mentioned, referenced Norwood and held that an assessment violated the 14th Amendment because an assessment that was confiscatory and out of proportion to the benefit received violates due process. And then the City of Commerce case, where it also relied on Norwood. So I'd also just very quickly draw the court's attention to the Tyler case, and if I may, just a few seconds. That's the Minnesota tax case from a couple years ago, where the woman was forced to, in a tax foreclosure, to sell her condo for a $15,000 tax bill, and whether or not the $40,000 value could be retained by the municipality. And what the Supreme Court said was the takings clause was designed to bar government from forcing some people alone to bear public burdens, which, in all fairness and justice, should be borne by the public as a whole. And that principle is the same today as it was when Norwood was decided in 1898. Thank you.
Thank you. Our thanks to both counsel. We'll take the case under advisement and move this morning to our second case, Christopher Pavel versus CTA. Mr. Duffy.
Good morning, and may it please the court. I'm Timothy Duffy, here on behalf of appellant Christopher Pavel, who's with us in the courtroom, and on behalf of myself. The district court dismissed Mr. Pavel's claim against the CTA and Clever Devices based on its conclusion that he intentionally destroyed signal messages on his phone on November 2nd, 2018. That finding, the district court rested that finding on the conclusion that Mr. Pavel's testimony about the deletion of those messages was not credible. And that conclusion, that Mr. Pavel was not telling the truth, is based on a very thin portion of the voluminous record in this case. In fact, it's only about 5 pages of printed text. And that is the form in which both the magistrate judge and the district court reviewed the matter. The first piece was Mr. Pavel's deposition testimony, where he was first asked about the deletion of the messages, and he said, well, it happened because we were both using Signal, and I'm not sure if Mr. Haynes' deletion, or Mr. Haynes was prompted to cross-delete. I don't remember what Signal was configured like at that time, and the court can look at this at 129-7 in the record, page 381. It's just literally not even 2 pages of deposition testimony. The second piece of evidence underlying the district court's decision was an affidavit from Aruna Harder of Signal that says the feature that allows a user to specifically delete a message from a thread, from a conversation thread that that person has sent, did not come into place until later in time. And that Signal has never had a feature that allows the recipient of a message to delete a message in a thread and delete it from the other phone. The third piece of evidence, and that, as you know from our briefs, is at 129-17, the Harder affidavit, it's only a couple pages. And then, and that was first submitted to the district, or to the magistrate judge in support of the CTA's spoliation motion. Mr. Pavel's first chance to respond to the Harder affidavit and what it meant for the case was in response to the spoliation motion. Not
Mr.
at a
Duffy,
hearing.
the problem was, though, that the court resolved this based upon your client's own statements, and he took inherently inconsistent positions in what he initially said, that, oh, this was because of Mr. Haynes's phone configuration. And when Mr. Haynes deleted the Signal conversations, they deleted on my phone too. And then Quest came back and said, no, that's not something that could have happened. And then he came back with a different story about the custom configuration on his own phone, which came only after the Quest affidavit and was inconsistent with what he had previously said, that this was Mr. Haynes's fault, not what he did. So that's what the court made the decision based on. And how is that clearly erroneous is ultimately what's before us.
Yeah, if I could, Your Honor, I don't think the court was thinking, and if it was wrong because the evidence doesn't support it. It wasn't that it was Mr. Haynes might have had something on his phone, but he clearly didn't. We know that.
But your client said that. Your client initially said, my texts or my communications on Signal were deleted when Mr. Haynes deleted his. It was Mr. Haynes's phone that configuration, when he deleted his text, that ultimately resulted in mine being deleted as well.
It wasn't necessarily Mr. Haynes's phone. It was Mr. Haynes's action that triggered the cross deletion. That is what he claims, and that is what he's claimed both in his initial testimony and his subsequent affidavit, that action taken by Mr. Haynes had the effect of deleting it on his phone as well. Now, in the deposition testimony, he said, well, he didn't know whether that was a further choice by Mr. Haynes or what the mechanism was. Harder says, well, it wasn't using this newer feature that allows you to delete specific messages. Harder did not speak, however, to what Mr. Haynes did. What Mr. Haynes said he did and what Mr. Pavle said he did was delete the whole conversation. And Harder's affidavit simply doesn't speak to that effect. It speaks to the cross-deletion of specific messages. His affidavit offers, for the first time, because...
How was the district court's decision here clearly erroneous?
Yes.
How?
Because if you look at these, if you read his testimony, his first testimony, and you read the affidavit and the Harder affidavit, and then you read his affidavit, there is no inconsistency. They are talking about two different things. The Harder affidavit only speaks to this specific, as we now know now, all of us, sometimes you could delete a specific message. That feature was not available, and there's no dispute about that. But Mr. Pavle did not say that feature was used first. He said Mr. Haynes deleted the whole conversation, and that somehow took them off my phone as well. The Harder affidavit did not answer that question.
It said it wasn't possible.
It said it wasn't possible.
Your client testified that the messages were deleted from his phone because of how Haynes's phone was configured. And the other affidavit said that just wasn't possible. And then your client gave a different explanation after reading the Quest affidavit.
He said it was not how Haynes's phone was configured, it was how Signal was configured. He says, is it your understanding that Mr. Haynes elected to delete for both you and him on your phone? Answer, it's possible he did that, but I can't stipulate as to how the Signal application was written in 2018. We would have to get the exact version of Signal that his phone was running and see what the behavior was. It's undergone changes since then. And then the question, what I'm asking
There
is...
was no mention in his original testimony about his own custom configuration of the phone causing the deletion of the messages. And that's what the magistrate judge and ultimately the district court found inherently inconsistent, because he initially said, oh, it was Haynes's configuration on his phone. And then after Quest said that wasn't possible, he came back with this custom configuration on his own phone. I have not heard any explanation as to why that isn't inherently inconsistent.
Well, even if it is that it was Haynes's phone and then his phone, he's asked for the first time, how did these, what happened to these messages? He admits he doesn't remember or hasn't looked into what Signal was capable of at the time. CTA came back with a very specific affidavit about individual message cross deletion. And in response to that, he offers the explanation of, well, the Signal affidavit didn't talk about what happens when you delete a conversation. Frankly, now that I can go back and look and explain to you, there's this other feature that could explain it. Now, whether someone thinks that proves he was right, or maybe it's a credible story, or maybe it's possible, that's something that should have been explored in a hearing or put for the jury, where you'd have been able to ask.
What basis do you have to argue that a discovery dispute should be decided by a jury? Jury trials are grounded in either in civil cases in the Seventh Amendment or statute, and you haven't identified here either of those, and I don't think you would ever find a case anywhere that says that an individual has a right to have a jury make a discovery determination.
Well, Rule 37 and then the advisory committee notes talk to this, and
They don't talk about a jury trial. They talk
They-
about that the judge can decide it based on a pretrial motion or a hearing or during a bench trial, that the judge can decide it. Rule 37 says nothing about giving a jury trial right for it.
it's not that Mr. Pavley was entitled to a jury trial right, to a jury trial on the issue of, whether he deleted his messages. It's that when the district court reaches.
So are
now,
you withdrawing that argument? Because I understood you to be arguing he was entitled to a jury trial on the question of intent for the discovery violation.
He was entitled to have an issue of his credibility that results in the dismissal of his case. That when the dismissal of his case turns on something that either he did or did not do, and the district court resolves that dispute based on an assessment of his credibility, based on a snippet of deposition testimony and an affidavit, that's a matter that has to be resolved, we think, by a jury. At a minimum, it deserves a hearing, and it's an abuse of discretion not to hold that hearing under Capco and other precedents from this court.
Let me, I know you're into your rebuttal time, but let me understand this happens in August. He's placed on administrative leave in October. Do we have anything in the record about when he retained counsel? We know he reached out to a lawyer in November, but do we have anything in the record about when he retained counsel? And is it your theory that he understood as of August through October, that he was to preserve all evidence? Are you conceding that, or do you have any issue with that? I can't tell from your briefs and your argument below.
We didn't raise that issue on appeal because the district court found that it was an anticipation of litigation. Mr. Pavley he was concerned at the time that he was going to have a claim against the CTA. He thought it had something to do with his medical leave and
Yes,
whatnot.
understood.
And he had inquired with a few lawyers. He had not retained anyone at that time. He didn't retain anyone until he retained me several months later or at least several weeks later, to bring this claim. So he did not have a lawyer at that time.
At that time, meaning October.
Correct.
And as of the November 2nd meeting with Haynes.
Correct. No lawyer.
But you are not arguing anywhere that he would not have understood the need to preserve evidence.
I understand. No, we did not raise that on appeal because that is something that the district court found, and it's very hard to argue that was clearly erroneous because it was possible there was litigation. I do think it's something the court should have taken into account in assessing the severity of the sanction. This is not something that happened, during the case or after it was obviously very clear to him.
Did you raise that with the district court?
Yeah, yes, in our filings on the spoliation motion and the objections, we did make those arguments, and certainly the issue of taking a broader view of the effect of any alleged spoliation and the actual practical realities of what his decision was when it comes time to say, I'm going to impose the most severe sanction possible on you by dismissing your case and making you pay a bunch of money. it is something the court should have weighed in light of his claim, in light of the defenses, in light of the practical considerations. I do just want to spend a minute, before I reserve another minute, on the Rule 37A5, that there's just no basis for assessing monetary award based on fees and costs under Rule 37A5. Some district courts have done it, but this court's never endorsed it. And this notion that it's okay because the rule says you can cure prejudice, it just doesn't hold up. First of all, you couldn't have a clear example in the text. They specifically allow costs 4 times and then don't the 5th time. And prejudice, I submit in the context of the rules, means prejudice in the case. We're going to limit the evidence, we're going to enforce a deadline, we're going to give an adverse instruction. This tortured reading of prejudice into, oh, let me make you financially whole as well, when that's not something that's sanctioned in the rule, I think is an important thing. I'll reserve my last minute for rebuttal. Thank you.
Thank you. Ms. Babbitt.
Good morning, Your Honor. Elizabeth Babbitt on behalf of the Chicago Transit Authority. I'm also arguing on behalf of our co-appellee, Clever Devices, and counsel for Clever. Michael Hughes is also present today. I want to turn first to the issue that Mr. Duffy was discussing with respect to the inconsistent statements that were made, and Judge St. Eve's point as to no showing of clearly erroneous. And to be very clear, Mr. Duffy characterizes it as a very thin record that the court hangs its hat on below. That's not the case here. The testimony that Mr. Pavley gave in his deposition was explicit and clear. There was multiple questions asked. Why aren't these messages on your phone? He testified at length as to how those messages came to not be on his phone, and he pointed directly to Mr. Haynes. He said, oh, I watched him do it. Mr. Haynes deleted it from my phone. I knew I had those messages on my phone, and then he selected the entire thread and deleted those messages. And Mr. Pavley goes on at length in his deposition, even saying, I felt like a third of my life was deleted because he was so upset and felt emotional that Mr. Haynes had taken that action against him to delete the messages that they exchanged between each other. And then there was the intervening affidavit from the Signal Chief Operations Officer, which confirmed, of course, that action that Mr. Pavley claimed had taken place was not technologically possible. That Signal did not have the technology wherein a user like Mr. Haynes could elect to delete all of his messages off of his phone, and it would force all the messages to be deleted off of Pavley's phone retroactively. That wasn't something that existed at the time. We produced that affidavit to Mr. Pavley in the course of discovery in, I believe, October of 2021, 8 months before Mr. Pavley offered his new version of events. Mr. Pavley, when he was confronted, and he says he is confronted with the statements that Ms. Harder makes in her affidavit explaining that what he had testified under oath wasn't technologically possible. He then submits a new affidavit, and in that affidavit he gives a lengthy explanation that's very technological, but the point of it is he must have had some settings on his phone that he arranged, which he must have had knowledge of since he was the one who elected to set them up on his phone, such that when Mr. Haynes deleted the messages from Haynes's phone, it caused them to be deleted from Mr. Pavley's phone as well. The magistrate judge and the district court judge, in viewing all of that, confirmed, without even really regard for what the Harder affidavit said, that Mr. Pavley's testimony was simply not credible. Magistrate Judge McShane refers to Mr. Pavley covering his tracks with his second version of events because
Was that second affidavit submitted in connection with the discovery motion?
the second affidavit was
Or I guess the first affidavit from him after his testimony and after Signal Chief Officer's affidavit was submitted?
yes. So the affidavit was produced at discovery, so Pavley had access to it. Sits on it. The CTA files its motion for sanctions to seek dismissal
And it's
of the
then
case.
that he submitted his
And then
affidavit.
he submits his affidavit. And, Mr. Duffy argues and continues to maintain that he was entitled to a hearing The Capco case instructs that no hearing is necessary in these circumstances. It's reviewed for an abuse of discretion. And what Capco provides is that the party, Mr. Pablo in this instance, must have notice of the issues that are presented and have an opportunity to respond. And Mr. Pablo had more than sufficient of both of those. He had plenty of notice. He had the ability to respond with an uncontested affidavit. The CTA actually moved to strike his affidavit because the CTA didn't have an opportunity to probe that new theory. The judge allowed it to be in the record and took it on its face, that was what Mr. Pablo's new position was. And so there was no need for the court to have a hearing to evaluate the credibility.
Let me make sure I understand this, because you do refer to Pablo's deletion of communications. Do we know that it was Pablo himself who deleted the communications, and what's the best evidence in the record for that inference?
So the court concluded that the only reasonable conclusion based on the incredible and evasive tactics that Pablo engaged in during the course of the case, the only conclusion would be that Pablo deleted those messages. There is no affirmative
There's
proof
no direct,
that
right.
Mr. Pablo, in fact, is the one who pressed the button. Now, I would submit that even if you take Mr. Pablo's second affidavit on its face, where he says that he arranged his phone to have these safety numbers, this technology in which it would force the messages, he still took that affirmative action to delete those messages by virtue of having that setting on his phone.
It's really a question we can look at both ways, but it seems like Pablo's underlying claim could have had merit, maybe, maybe not. It wasn't a frivolous lawsuit he was filing against CTA. So why is it reasonable for the district court to infer foul play, bad faith on his part, when he had an essentially, at least on his face, a sound lawsuit, and all of this happened during a time when the lawsuit had not even been initiated? The lawsuit doesn't actually start until about a year, a little over a year after all of these events in this kind of October-November timeframe.
So, Your Honor, respectfully, I would sort of divorce the merits of his claim in his case and the court's ultimate determination as to the sanction of dismissal. But with respect to the timing of the deletion of those messages, the court concluded that Pablo had an obligation to preserve, that his obligation to preserve the evidence was triggered as of October 29th of 2018. And that's when it's undisputed Pablo was communicating with attorneys. He was communicating with Mr. Haynes, his supervisor, about how he intended to sue the CTA, and was evaluating those claims. And Mr. Pablo, even in his deposition testimony, he testifies the record is 129-7 at 536. He testified himself that he knew at that point, or relative at that point, that he had an obligation to preserve evidence. So he himself concedes that. But the fact that ultimately the court determined that dismissal was appropriate, even if he did have a meritorious claim, was because the CTA could never have a fair defense. The relevance and the significance of the messages that were deleted, it wasn't simply just messages with a third-party witness that may have had something to do with the litigation. Mr. Pablo was bringing a whistleblower claim against the CTA and against Clever, and he intentionally deleted, by the finding of the court, the messages that he exchanged in real time with the person he claimed to blow the whistle to. So all of those messages, all of the communications they may have had about whether or not, some of the messages that were preserved by Mr. Haynes suggested, just throw me under the bus. Pablo messages Haynes, sorry, I'm gonna have to make you be the bad guy. All of the information that we still were able to get from Mr. Haynes, not from Mr. Pablo, would suggest that perhaps he wasn't a whistleblower, and the CTA will never have the full access to those messages because Mr. Pablo took actions to purposely make sure that the CTA did not have access to that information. So turning to the
Ms. Babbitt, can I clarify, if you can, there was a roughly $53,000 amount that was awarded did that include the fees and costs associated with the motion to enforce the subpoena? Or did that only involve the discovery costs leading up to the motion?
I believe that amount also included
Both?
the paper, the pleadings, and the fees associated and costs. I don't know if there was actual costs associated with that paper, Your Honor, but yes.
By paper, you mean the filing of the
pleading,
motion?
Yes, and preparation of it. And I'd like to turn to the Rule 37A5 issue, which is the issue of whether or not Mr. Pable appropriately opposed the motion to compel such that sanctions are not appropriate. And so Rule 37A5 provides that when a party opposes a motion to compel, that the party that files the motion to compel or a discovery motion of that sort under Rule 37A should be made whole, that the party should be entitled to receive its fees if the opposing party did not have a reasonable basis to oppose it. And I think it is sort of in the extreme for Mr. Pable and Mr. Duffy to maintain that the opposition to the motion to compel was a well-taken opposition. The CTA engaged for months in trying to get discovery. We received a phone in discovery that was effectively blank. It had less user-generated data than if you had bought a phone from the Apple Store. When we finally got the phone that Mr. Duffy had maintained was a complete image of the phone, a representation he made both to the CTA and then ultimately to Magistrate Judge McShane in a hearing. And Mr. Duffy continued to maintain that position throughout the litigation until ultimately the CTA had a second image done, which confirmed that in fact Mr. Duffy had never had an image taken of the phone, that Mr. Duffy had never directed his third-party vendor, Quest, to even prepare an image of the phone. And so for those reasons, the CTA should be entitled to the fees and costs associated with its Rule 37A5, its motion to compel. On that same track, the Section 1927 sanctions should also be affirmed against Mr. Duffy. Mr. Duffy clearly engaged in vexatious conduct and unreasonable conduct in his pursuit, in his taking position throughout the litigation with respect to the phone. He knew all along that the CTA sought a complete image of the phone. He knew what an image of a phone meant as a practicing attorney, a sophisticated attorney, and he made representations throughout, first claiming that the CTA must have wiped the phone, and that might be why there isn't sufficient data on the phone. And then ultimately when it's confirmed that of course he didn't have the phone imaged and that the data had never been properly preserved, he pivots to, well, it's not that big of a deal. The information on the phone would not be that relevant, and how could we ever point to anything? And it leaves the CTA and Clever in a position where we will never know what was on the phone. It wasn't preserved. It wasn't preserved on October 29th of 2018, and it wasn't preserved even in June of 2020 when Mr. Duffy first informed the CTA in discovery communications that he had just imaged the phone. He never imaged the phone, and he continued to play a game of wordplay, acting as if we all weren't sure what we meant by an image of the phone throughout this case. And that was why the court ultimately determined that this was the sort of vexatious and unreasonable conduct that warranted Section 1927 sanctions. For all of these reasons, I would ask that the court affirm the entry of judgment and the dismissal with prejudice of the case and affirm the award of sanctions against Mr. Pable and Section 1927 sanctions against Mr. Duffy. Thank you.
Mr. Duffy.
I urge the court to look at what Ms. Bobby characterized as extensive testimony. It's 3 answers in a page. Yes, he went on to say he was actually emotionally hurt by Mr. Haynes' deletion. I think that enhances the possibility that he's telling the truth as to what occurred on that day. But let me address this issue of the.
Well, before you move on,
Yeah.
the magistrate judge then he says in that, I was hurt, I felt like a third of my life had been deleted, but he also had testified that he had at that time a 50 message cap, and she couldn't reconcile the two, a third of his life and a 50 message cap. Can you just speak to that if you
Yeah.
want us to look at that testimony?
I think he was referring to his connection to Mr. Haynes was such an important part of his life, not that the particular messages that they happened to exchange over the last 50, I think it would have been at that time, were that significant to his life. I would note to the court too, you can look at this 12918. These are messages from Mr. Haynes' phone that pick up the moment after that Mr. Haynes deleted. There's no question Mr. Haynes deleted messages, and then they pick up, and we've got pages and pages and pages over the following days, some of which Ms. Babbitt talked about. So, and these folks are not hiding messages. They're making very candid statements about the case and their circumstance. So the notion that the messages, that preceded this were somehow fundamentally different, all of which were written, nowhere near the time of the events at issue is pretty thin. If I might have just another minute to talk about the timing of the Harder affidavit.
Your time has expired. Thank you.
Thank you.
Our thanks to all counsel. The case will be taken under advisement. We'll move to our third case this morning. Upchurch versus the State of Indiana. We'll just wait for the courtroom to clear. Mr. Darst. Okay, come on up, Mr. Darst. Good morning.
Thank you, Your Honor, and may it please the court. This is a classic case of race discrimination. The African-American plaintiff, Timothy Upchurch, has impressive qualifications as a lieutenant at the Correctional Industrial Facility, the CIF, at Pendleton, Indiana. He was the 2016 CIF Supervisor of the Year. He performed the captain's duties when the captain was absent and for about 2 months after the captain left. The captain recommended Upchurch for the captain position in 2018. Mr. Upchurch was rated as exceeds expectations for the year 2018 when he was doing the captain's job. But CIF had not promoted any African American above lieutenant for years, since 2012. CIF deviated from its policy of promoting from within, which the warden stated in an email later, and promoted a white lieutenant from outside CIF to the CIF captain's position. The CIF then instructed Timothy Upchurch to train the white new captain, the lieutenant from outside the CIF, how to do the CIF captain's job. Timothy Upchurch complained about the race discrimination and about not promoting any African Americans above lieutenant. When he was told that he was not promoted, he was told this in April of 2018. CIF did not investigate his complaints. After he was told to train the white new captain how to be the CIF captain, he complained again, complained that he was told that he would not have to train the new captain, and then they told him to train the new captain.
Mr. Darst, it doesn't look like you took any depositions in this case.
Correct.
Including of the decision makers.
Correct.
Which I found surprising given that you have the burden of proof. Can you shed any light on that? Was there any particular reason?
Your Honor, the testimony was through affidavits, and if I may speak to that burden of proof, that is often stated And that is true for the case. But on a motion for summary judgment, the burden is on the moving party to prove that there is no genuine issue of material fact.
But you have to put forth evidence that would refute that, and you ultimately want to go to trial and win or settle it. It just seems
Yes.
surprising that you didn't take any depositions, especially of the decision makers.
The decision makers had an opportunity to tell their side of the story through their affidavits. And they, in fact, lied about the date of his complaint to Deputy Warden Cole and Major Fox. They tried to say that his complaint was after his demotion, when he was complaining about his demotion, and saying that he complained about the lack of promotions of African Americans. So they lied in their affidavit. I don't have confidence, or didn't have confidence with these facts, that the decision makers would tell the truth in a deposition. And
Wouldn't that be good for you, that you could impeach them?
well, it's difficult to show when someone is lying, as you know. And it's difficult from these affidavits to show that they're lying. But you have to look at them when they're saying, well, the warden said I knew about his complaint to Deputy Warden Cole and Major Fox that there were no African Americans promoted above lieutenant. And then they changed, then the Deputy Warden changed that and said, well, that meeting occurred on February 20th, the following year, 2019, which is false. That meeting occurred when they told Mr. Upchurch that he was not promoted. He wouldn't complain about promotions when he was demoted. He was complaining about the lack of promotions when he was told that he was not promoted. And that was the testimony. As a matter of fact, the entry of the court recognized that he made that complaint in April of 2018, not 2019. So when you're faced with years of discrimination, you're faced with, as a matter of fact, here's another fact, if I may point out to you. I was asking Tim Upchurch the same question. Why did they give, what reason did they give for demoting you? And he said they didn't. And I asked the deputy warden why. And he said, ask the warden. I asked the warden why. And she said, well, you've been a hindrance to me since I got here. Now, they didn't give him any reason for demotion. They didn't give him, so for me to depose, what would a deposition do? I don't know. So, and as a matter of fact, there's another reason is because of the lack of funds and the cost of depositions. If we had, there are so many facts in this case, if we had to track down every excuse that the employer was given before the employer had to give it, it would be terribly expensive. We would never be able to afford that. As a matter of fact, the court said, well, we don't have the employer's records here, we don't have the employer's records there, and implied that the employee had the burden to produce them. The employee didn't have the records. The employee asked for numerous employment records, employment files. We received them. We put them in the record. We summarized them for the court. And yet the court said, well, there's this possibility over here, or there's this possibility over there, and implied that it was our burden to seek out things that were tangential and were not of any substance at the heart of it. So I would hate to have a rule saying that for a motion for summary judgment, in the even before the motion's filed, you have to take depositions. And especially in a case here where there are years of discrimination, there are years of facts, we would be chasing ourselves. Maybe that gives you some of the feelings that I have as to why I wouldn't take a deposition in this kind of case. Does that help? Okay. The defendants did not do any investigation of the complaints of discrimination of Mr. Upchurch. As a matter of fact, the state said, the state abandoned its duty and said, we're not the employer of this state employee. The Department of Correction is the employer. Now that is a new claim that has not been raised in other cases. As a matter of fact, cases that we've handled before, Knox versus State of Indiana, which involved the Pendleton Complex, another building there, and Orton Bell versus State of Indiana, which is the Pendleton Complex. The state admitted that the Department of Corrections employees were state employees. As a matter of fact, last year, in the case of Galvan versus State of Indiana, the state admitted that Galvan was an employee of the state when he was working in DCS, the Department of Child Services. In this case, the state changed and said DCS and the departments, the DOC, Department of Correction, are the employers and not the state. That would be a terrible situation if every department was treated as an employer. The departments are not legal entities, as shown by Burris versus the state, and which was also affirmed by this court on appeal, finding that the lottery commission had income, it had assets, it had authority to sue, it had all of those things. And so they were a suable entity and an employer. In this case, the Department of Correction has no income, no assets, no anti-discrimination policy. It would be terrible for them in any case because they have no policy against discrimination. They rely on the state policy. Neither the state nor the DOC enforce the policy against discrimination. So with no income, no assets for the Department of Correction, if we got a judgment against the Department of Correction, it would be a worthless judgment. Their judgment proves they don't have any assets. If the state pays it, then that shows that the state is the employer, is more evidence that the state is the employer. So the employer will say, as a matter of fact, if the department was an employer, and every department of the executive branch was an employer, we would have to sue the Department of Correction and the state personnel department, and perhaps the state itself, as separate entities who were cooperating together in a conspiracy to allow race discrimination. That would be a terrible situation for us, for anyone. It would be terrible for the departments, it would be terrible for the state. So this new effort to eschew or to abandon the employer's duties by the state is a situation that none of us would want. Thank you. Let me reserve my time if I may.
Thank you. Ms. Recker.
Thank you. May it please the court. I just want to start by addressing something that Mr. Darst said. There's no evidence that the defendants lied in their affidavits. And we argued, I believe from the beginning, that Mr. Upchurch had reported to Deputy Warden Cole in April and May of 2018 that he believed that the department should be hiring more African Americans or promoting more African Americans into the captain's position. I believe what he's talking about is that there was another meeting with the deputy warden in June of 2021, I believe, where he had again said, made the same comment. Also, in Warden Knight's affidavit, she says that she wasn't aware of the complaints of discrimination until after the demotion.
What steps did the IDOC take to investigate Mr. Upchurch's complaints of discrimination? He had some formal ones, the step ones, 3-step ones, separate and apart from what he characterizes as more informal conversations. And do we have anything in the record supporting the idea that the IDOC looked into these complaints?
The only thing in the record is that the complaints were denied. If you're talking about the civil service complaints he made after the demotion, that the complaints were denied. And then that's what ultimately led to him filing the complaint with the Civil Rights Commission. I'm not sure there's anything in the record as to the steps that were taken to address those complaints. But Upchurch doesn't argue in his summary judgment briefing or in his briefs before this court that the department failed to take steps when he made the complaints in the civil service.
Well, he absolutely does argue that IDOC didn't do anything in response to his complaints about discriminatory promotions or failure to promote African American employees at the prison. That he does say.
Yeah, yes, he does say that. The complaints that he made to the deputy warden, he said that the department wasn't promoting African Americans into the captain position. But I think the complaint he really makes in his brief, if I'm remembering correctly, maybe in his reply, is that the department hadn't investigated the complaints of harassment regarding Lieutenant Ridgway. I don't know that he makes a big deal about the department not investigating the complaints when he said that they weren't promoting African Americans. And those complaints regarding Ridgway weren't related to his race. They were more related to Ridgway.
It's in the gray brief, and then Mr. Darst just repeated it today. So you can move on.
I'll start with the discrimination complaint. The department presented legitimate reasons for the demotion and for failing or declining to promote Upchurch thereafter. The department demoted Upchurch because he failed to intervene or report peer-to-peer harassment between two officers that he was supervising. The HR had investigated the complaints that were made and determined that that it was Upchurch that knew of the harassment and didn't intervene. Upchurch points to Officer Palmer and Captain Perro as comparators, saying that they were treated better in regards to his demotion because they weren't disciplined. But there are material differences, so they aren't comparators. For starters, Palmer was a correctional officer. He wasn't a supervisor of Officers White or Myers at the time. So he had different duties and responsibilities. And in regard to Captain Perro, he was a supervisor. He was the captain over Upchurch. But there is no evidence from the investigation that Perro was aware of the harassment or that he heard the comments that Officer White had made. So he failed to point to any similarly situated employees who were treated better or any evidence to show pretext in regards to the demotion.
And that's not the occasion where Myers says Perro was in there and heard the thing repeated about White.
Yes, that is the incident, but I don't believe that in the investigatory report it says that Perro heard anything. He's not mentioned as being in the shift office at the time.
The investigatory report didn't address Myers saying Perro was there and heard it, you're saying?
The investigatory report under Myers' statement doesn't mention anything about Perro being in the shift office at the time. Upchurch testified during his deposition that Perro was in the office. But you have to look at what the employer knew at the time and not necessarily whether the employer's decision was correct, but whether they honestly believed. And based on their investigation, they believed that Upchurch was the one who failed to report the harassment or intervene, and that Perro didn't know about the harassment. Moving on to the failure to promote or transfer Upchurch. The facility has a practice that if an employee is formally disciplined within 12 months, they can't be promoted within the facility. And so there were 6 positions that Upchurch applied for at Correctional Industrial Facility in which he wasn't eligible. There were 2 positions that he applied for that he was eligible, but the department presented evidence that the 2 people that Warden Knight selected for those positions she believed were better for the job. Specifically, Brandon Ritchie was hired for the lieutenant position. He had been a sergeant at a different facility, and she thought he was desirable because he had experience with at-risk offenders, and the facility's population of at-risk offenders was increasing. And then Gilly was hired for the captain position, and he had previously been a captain at the correctional industrial facility prior to transferring to another facility to gain additional experience. And so she hired him because of his work history, and she thought he could hit the ground running when he returned to the facility. So there's no evidence that the department's reasoning for hiring Ritchie or Gilly was pretextual. And then in regards to the other positions that Upchurch applied for at the other facilities, there's no evidence that Warden Knight had any influence on those decisions whatsoever. Nor is there evidence that she influenced DCS's decision to not hire Upchurch as well. And then as to his retaliation claim, the department also presented evidence that had legitimate reasons for the demotion and for not promoting or transferring Upchurch. In regards to the demotion, as I mentioned earlier, there's no evidence that Warden Knight knew of the complaints of discrimination prior to the demotion, so there can't be a causal connection if she wasn't aware of those complaints. And then in regards to the failure to promote, Deputy Warden Cole had legitimate reasons for disciplining Upchurch, which led to him being ineligible for promotion for 6 of the positions at Correctional Industrial Facility. The first, he failed to work overtime in January of 2019 and was disciplined. In March of 2019, he took unauthorized leave. July of 2020, he also took unauthorized leave. And then in February 2021, he brought tobacco into the facility. And again, there's no evidence that the deputy warden's reasonings were pretextual to support that it was based on his complaints of discrimination.
The tobacco incident seems a little funny. Not haha funny, but the Upchurch is saying he asked to review the video. He was denied. He asked to have a witness, someone review the video with him. He was denied. He asked him to produce the video. He has a series of irregularities that he wants us to look at with regard to this, which was his ultimate sanction. You know, it's toward the end of the case and the facts in the case. And then he does say he had this Major Gilly look at the video with him, who agreed it doesn't show him dropping some tobacco. So I'd like you to address that, you know, this tobacco situation. And of course he says in his affidavit, I don't even use tobacco.
Right.
But this results in a 10-day suspension. So I wanted you to address some of Upchurch's arguments about why this tobacco incident is suspect.
Well, again, you have to look at what the employer honestly believed, and you can't consider, I guess, whether they're mistaken. Most of Upchurch's arguments go to that the deputy warden was mistaken in his belief, but the deputy warden reviewed the video, and he believed that the video showed tobacco dropping from Upchurch's pocket, I think, when he was walking through into the facility, and there's no evidence that that isn't true. And I believe that Upchurch actually did review the video.
Yes.
And so even if the deputy warden was mistaken, that doesn't show that he didn't honestly believe that it was Upchurch that brought the tobacco into the facility. And I also want to add that the video was provided to Upchurch during discovery. He could have produced the video as evidence to show that the deputy warden was lying, was not being truthful. That's not in the record before us. So I think that most of Upchurch's arguments are that that he didn't actually do it, that he didn't actually bring the tobacco in. But again, like I said, you have to look at whether the deputy warden's belief was honest. And here there's no evidence pointing that it wasn't. And then I
The
briefly.
timing of the February 20th reprimand is concerning, because it was one day after he complained, after Mr. Upchurch complained about discrimination to Deputy Warden Cole, and the next day he reprimanded him, which is very close. I know timing alone often isn't enough. We've said in some circumstances it can be. That was one day later. How do you respond to that?
There's evidence in the record that the deputy warden was already planning to discipline Upchurch prior to Upchurch coming to speak with him. There's evidence that Ridgway had provided reports that Upchurch hadn't, I believe that was the unauthorized leave, or that he failed to work overtime in January on 2 different occasions. So we know that when Upchurch complained about the discrimination, the Deputy Warden Cole was already planning to discipline him. There are lots of cases that say that timing alone isn't enough. I know the Watermill case that Upchurch cited, I believe that was almost like instantaneous. He complained.
This was one day, though. That's, while not instantaneous, it's not that far off.
Right. I agree that it was close in time, but there's also, like I said, evidence that he was already planning to discipline, and that Upchurch doesn't deny that he had refused the overtime. So the timing alone shouldn't be enough where there's no other evidence indicating that the deputy warden's decision was pretextual. And then I just want to briefly mention the employer issue, who the correct employer is. This court in De Silva held that it's the agency that is the employer. It takes an agency-specific approach in order to promote parallel treatment and ensure that it's the defendant that can provide a remedy. It's the entity with the actual hiring and firing responsibility, and here that was the Department of Correction, not the state of Indiana. Upchurch doesn't really provide any reason as to why this court should deviate from that holding in De Silva.
What we haven't addressed, I understand the argument you're making on the employer, is the IDOC's discretion it has, or how it chooses between informal discipline and formal discipline. And Upchurch did present other employees at the CIF who got informal sanctions. And he consistently got formal sanctions, which of course prevented him from, eligibility for employment. So how is that disparity not evidence for Upchurch that he was being targeted to avoid his promotion?
Your Honor, he didn't provide specific evidence regarding those employees' employment history, which is important because the department uses a progressive discipline policy. And so without having all of this evidence regarding those other employees, we can't determine whether they were similarly situated and treated more favorably. The Bogway, I believe it's the Bogway case that we cited in our brief, talks about that you have to have evidence, specific evidence about these employees so that you can determine whether there are material differences and whether the differential treatment was due to race.
So your position is not enough that he says, Delph, here's what he did, here was the sanction, here's Raines, here's what he did, here was the sanction.
No, Your Honor, because we have to have their discipline history to know whether the difference was due to his race, or whether it was because maybe they had no discipline prior to that, and Upchurch had. So in order for it to be a comparator, we have to have more evidence than we do in this case. The department asks that this court affirm the district court's grant of summary judgment. Thank you.
Thank you. Mr. Darst.
Thank you. The defendant produced the personnel files of the employees that were in question that you asked about. We introduced those into evidence. I believe those documents show the disciplinary history. As a matter of fact, we referred to them in our summary of those employees. What they had done when they were promoted, when they were given discipline, as the judge said, given informal discipline. So to say that we didn't produce evidence of discipline is not correct. If there's something that the Department of Correction knows, some other record, they have to produce that, and that's what this court has said in the documents, in the decisions, talking about the summaries of histories and employment histories. So the argument of the employer is maybe this or maybe that. That's not sufficient for summary judgment. They can argue that at trial, but not for summary judgment. The employer said that the decisions talk about agency. What the decisions mean by agency is an entity, a legal entity. We can't, none of us can sue something that's not a legal entity. And that's what that's the first requisite. And then who the employer is the employer that has the final authority. The state lied, or the employees lied, when they said that the warden has the final decision. The warden does not have the final decision. That was stated in the recent case from the Indiana Court of Appeals. The governor has the final decision. The governor has the final decision in litigation cases, and in this case, the warden can't settle this case. It's the governor that has to settle this case. The warden has the initial decision. Maybe she has the final decision in the institution, giving the benefit of the doubt to the employer, to the state, as to what in the world they're talking about. Maybe that's what they're talking about. But is she unsupervised? That's what the state is arguing. She's unsupervised. I don't believe that's what the policies and procedures in the law require. The law requires supervision. The law can't have the law does not say that the discriminator has the final decision. It has to have the final decision. And the state falls back on honest belief. That's a pretext argument. And there's a lot of evidence that Deputy Cole did not believe that Upchurch had tobacco. He showed it in the video once, and Upchurch said, let's see it again. He wouldn't show it to him. Upchurch's supervisor agreed with Upchurch. They did not give Upchurch a tobacco test, which is provided for by policy. And those are the kinds of evidence we have on each of the acts. They're too numerous to go through, but there's the evidence of discrimination for years. Thank you.
Thank you. Our thanks to both counsel. The case is taken under advisement. And our fourth case this morning is United States versus Lenny Perry.
Good morning, Your Honor. May it please the court. Andrew Fink on behalf of Lenny Perry. Less than 2 questions into his cross-examination of the first witness. Proceeding pro se in this case, Mr. Perry realized he was in over his head. He couldn't get a single question out without an objection, and ultimately, in frustration, he asked for counsel to be appointed for him. Standby counsel, who the court had previously appointed because this was a complex case, because he required assistance with substantial matters in the case, and to assist in any way necessary at trial. After making that request, the government specifically requested to the court that it have a colloquy on the matter. They inquire into whether or not Mr. Perry's invocation of the Sixth Amendment was warranted here, a warranted appointment of counsel. The court denied that request and instead assumed that the request, or framed the request as a request for continuance, and denied that as well.
Let me ask you this. If the court had, instead of denying and finishing the conversation and moving back to the trial, had asked standby counsel if he were prepared to take over, and standby counsel had said yes, would the district court be within its discretion to deny the motion for counsel at that point?
I think that would have been that is one of the, I think the crux of the error here is that there was no inquiry, and so we don't know from the record whether or not a continuance was necessary. I think it's because there isn't in the record anything to support that we have abuse of discretion here. Without knowing how counsel would respond, I think the question could become more complex, so I wouldn't concede that there would be no error. But as it stands, we don't even know whether or not there was a need for a continuance here, because he never asked counsel, and because there was reasons to believe, there's every reason to believe, that counsel was prepared to go for it. Even
Mr.
if
Fink, is your argument here, because I'm hearing different things, that your client was deprived of a fair trial, or that he was deprived of his Sixth Amendment right to counsel?
I believe that because he was deprived of his Sixth Amendment right to counsel, his trial was manifestly unfair. He wasn't able to articulate and enter into evidence. Granted, some of the things he was trying to enter into evidence, especially on that first day, would be considered harmless error.
What about his statement the next day that he wanted to represent himself?
So I think this is
Because
really...
is it your position that a defendant throughout a trial, once the jury is in and jeopardy has attached, that the defendant could go back and forth, well, I want a standby counsel today, tomorrow, no, I want to continue to represent myself?
So I think there are two things there. Absolutely not. Our position is not that throughout trial that you have this kind of get out of trial free card and that you can just tap out and tag team. This court has made very clear that hybrid representation is disfavored. I think there are two things about the request the next day. One is that my understanding is that it actually doesn't come, what the government has framed a waiver the next day of Mr. Perry saying he wanted to go forward. My understanding is actually it's standby counsel who says that they spoke together and that Mr. Perry wanted to proceed forward. At that point, I don't think it's technically something that standby counsel can do, because he's not representing Mr. Perry and can't speak on his behalf and can't actively waive that right for him. Second of all, that is just, again, why we're here. There should have been an inquiry. There should have been a Ferretta inquiry into whether or not that waiver was knowing and voluntary.
Well,
there wasn't.
It wasn't a waiver of counsel question. He had already waived his right to counsel previously. By my count, standby counsel was the sixth lawyer in the case. There comes a time, and we have many cases saying this, where those repetitive colloquies can cease and the defendant can be forced to live with his choice.
Absolutely, Your Honor.
And this is one of those occasions when you get to number 6.
I think that the actual number, I agree, is there are quite a few, and that does weigh in. That's why this is kind of a tricky case. I think the thing that distinguishes it and why you can't just go based on X number of attorneys is that the court itself acknowledged that it had misapprehended his level of experience. I think it was on page 174, 175. As soon as he makes the request in the trial transcript, as soon as he makes that request, Mr. Perry says, well, I don't know how to get this evidence in. And the court responds, well, I thought you understood this, and I'm sorry.
That's a too late kind of comment. It's not the judge second guessing his previous Ferretta ruling. That's just reinforcing his previous warnings that this is a bad idea. You shouldn't be doing this, but you're doing it knowingly and voluntarily. Not because you're going to do a good job, but because you're knowingly and voluntarily waiving your right to counsel and exercising your right of self-representation. And the court had been there before with him on 3 prior occasions. So, again, there comes a time when the additional layer upon layer upon layer of process is unnecessary, and the defendant can be forced to live with the choices that he previously made.
I agree. And we simply argue that at this point, because of that, because the government requested the colloquy and because the court...
That's irrelevant. What's important is the defendant's behavior here and whether the judge took a valid waiver the last time around, to say nothing of the previous 2 times around, although ultimately he was given new counsel, so he wasn't... there weren't rulings that he validly waived his right to counsel. It was the continuous failure to cooperate with counsel that led him to this point, and he was warned many, many times
Well, I think you're,
previously about that, and there was a thorough and valid Ferretta hearing against the defendant's wishes the previous time when he was granted the right to exercise his right of self-representation with standby counsel, whom he didn't want and objected to.
I think that's a very important point. I think all of those that you're going to make several important points. One, that the primary reason for his rejection of counsel previously was his inability to cooperate with them. That resulted in 6 different counting, going through so many different counsels. And despite his protestations to the contrary, the court tried to use belt and suspenders and make sure there was counsel standing by because this was a complicated case, because he anticipated that there may be an issue once he went to trial. When he ultimately went to trial, he immediately realized the error. The reason why he was asking for new counsel wasn't because he wasn't able to cooperate with his current counsel. It's because he realized that he had no ability to proceed and no ability to represent himself and enter evidence, and that he would not get a fair trial as a result.
He had been warned of that
Yeah,
through a perfectly appropriate colloquy, thorough.
Well, I think that's one of the issues here, is that the judge, I think, overestimated his ability to represent himself and his awareness of the rules of evidence because he had previously done so in state court before. There's no indication that prior state court hearing was in front of a jury, involved any rules of evidence. The court said as much and instead assumed that he was familiar with the rules of evidence.
Are you saying that would be sufficient to reject his choice to represent himself?
Well, I'm saying that this is what the court's Ferretta decision was based on. And the analysis requires the court to look into the prior experience of the defendant.
He said he had represented himself successfully before.
I understand. I think that the point is, or my point is that the court took that to mean one thing, that he had a familiarity with the rules of evidence, and then it soon and based his decision in part on that. And then the court, once Mr. Perry went to trial, acknowledging that it was it was kind of like a too bad so sad moment, still acknowledged that there was this misapprehension as to his level of experience, and that directly affected his decision to request counsel here.
Mr. Fick, I'm not sure you answered Judge Jackson-Cumi's question about if a continuance had been required, if standby counsel said, I am not ready to proceed, I need more time, would the district court have been within his discretion to say denied?
Oh, I had actually asked
We're
if
moving
standby
forward.
counsel said he was ready to proceed.
Okay, I have the flip of it. If he had said, I am not ready to proceed, I need more time, would the court have been within its discretion to say denied, keep going?
I think if the court had done an inquiry and made findings regarding the need for a continuance, then under Tolliver it would. Because Tolliver says, absent deliberate misrepresentation, the logistical planning and the fact that they actually, there was this, in Tolliver, the court looked for 29 different attorneys and was unable to find them. The court actually said, we're going to continue looking for an attorney as we continue going through trial. That's just not the case here, and ultimately that is kind of the crux, that there was no inquiry.
Now, your point about the judge misapprehending Perry's experience, I take you to you're not faulting the judge or claiming error there. Your point is that when we get to the middle of the trial and the judge says, you do not have an understanding, I'm sorry about that, I thought you did. You're saying that's the judge recognizing there is now a new issue that has cropped up, calling into question one of the foundations of the judge's Ferretta findings. Am I following? I'm following you, and therefore that necessitated in that moment the inquiry you were asking us to say was proper, should have happened.
Absolutely, Your Honor. And I would say in addition to that, I think that it would also inform the judge's, the reasons for the judge having appointed standby counsel in the first place. That's one of the reasons the judge really needed to ask standby counsel if they were prepared to proceed. This is one of the reasons that the judge had appointed counsel, was if that understanding of Mr. Perry's acumen was flawed in some way, and it turned out that it acknowledged that it was. Based on that, we believe that the judge should have performed an inquiry just so we at least know on the record whether or not this was due to, whether a continuance was necessary. And I think that's even, just as one final point, at this point when the judge made this ruling, the court believed that it was going to proceed with another witness that day. It wasn't until after this ruling that the government rested because they couldn't bring a witness. And even then, the judge didn't use that extra time to perform an inquiry. There was no need to even break up the trial that day. They could have had a colloquy and started the next morning without any delays to the trial. Thank you.
Thank you. Mr. Kerwin.
Good morning, and may it please the court. Brian Kerwin for the United States. Your Honors, the district court did not abuse its discretion in denying defendant's mid-trial request for counsel on the grounds that it would cause delay. As Judge Sykes alluded to, defendant knowingly waived his right to counsel after 5 different lawyers were appointed to represent him, none of whom he would work with because they refused to try the case in the way that he wanted them to try it. Thereafter, he repeatedly objected to having standby counsel at all. He accused Mr. Legutke on June 3rd, when he was appointed, of conspiring with the government, of having a conflict of interest. He repeatedly complained in written filings thereafter that standby counsel was being forced on him. And it was with that backdrop that when Mr. Legutke was appointed, he specifically asked the district court to outline, quote, the parameters of his duties, noting that he had been appointed in other cases as standby counsel in front of Judge Leinenweber, and those duties can vary. The district court explains, I'm appointing you to assist in whatever way the defendant requests. But it was not all that surprising given what counsel had said at the June 3rd hearing and the many lawyers he had cycled through before, that he'd never reached out at all.
Picking up on that language from Judge Leinenweber, I'm appointing you to assist in whatever way Mr. Perry requests. How do we know at the moment Mr. Perry says, I can't do this, I need an attorney to take over, what he's asking? How do we know if he's asking in that moment for standby counsel to take over the cross-examination, for standby counsel to take over and represent him for the remainder of the trial? How do we know whether he's asking for a continuance or not? What do we know in that moment?
In that moment, Judge, we know everything I just described, and we know what occurred that morning on October 28th. When the parties came to select a jury, Mr. Legutke made clear that the defendant had never reached out to him to conduct any significant legal work, and that the only actions he had taken in the case to that point were ministerial, namely serving trial subpoenas at the request of the district court.
I'm asking you, what do we know about what Mr. Perry is asking in that moment?
Well, we know what words he used, and he said, I want standby counsel to represent me. I have a Sixth Amendment right. I want him to try to get my evidence in. I think the most common sense understanding of that is that he wants him to stand up and be appointed to take over.
And let me ask you this. What do you see as the harm of the judge asking those questions? I note that the government did, to its credit, say, pause, Judge, we need a pause here. Let's talk at sidebar.
So I think out of an abundance of caution, the line assistant asked, can we have a colloquy? And I think he used the words to determine if he wants counsel to represent him going forward.
Mm-hmm.
And
So asking the same kind of question I'm asking here.
Same kind of question you just asked, exactly.
Yeah.
Does he want him to come in for a period of time or for the entirety of the case? I think regardless, Judge Leinenweber was not clearly erroneous. In fact, he was dead on that whether he was coming in for a portion or for the duration would require a delay. And that's because, as he found or explained in his post-trial ruling, the standby counsel was not up to speed on the complex issues of this case, and it was not fair to ask him to come in and conduct 13 cross-examinations and put on a defense case that would satisfy the defendant. And so whether he was asking him to come in at that moment and take on this massive burden that he'd explained in the morning he was not prepared to do, or asking him to come in as essentially co-counsel in violation of the rules against hybrid representation, a delay would be virtually guaranteed.
Is there a mismatch here in some of the messaging about standby counsel? Because early in the case, judge appoints standby counsel and instructs standby counsel to be familiar with the case and the facts and so forth, so on. So standby counsel has to be familiar. And so then we get to the moment where Mr. Perry realizes he's in over his head and then asks for counsel to step in. How is Mr. Perry to know, separate and apart from what he asked him before to do? I acknowledge what you're saying. He didn't ask him to do very much in preparation for trial. But judged against the earlier thing that standby counsel is supposed to come and be familiar, is there a mismatch there for any defendant, not just Mr. Perry?
Well, in this particular case, or a case like it, I don't think it so much matters as what Mr. Perry thinks he can do in terms of tagging counsel in or tagging back in himself, having him come in for a portion of a witness, or at a moment's notice to take on this complex case. What matters is whether the district court is in a position to properly assess whether having him tag in at all is going to cause delay. And in a case where there's 7 victims of sex trafficking who are there to present testimony about the trauma that they lived through, in a case where the government has repeatedly asked to go to trial to vindicate their rights, and in this heightened setting that we were in October of 2021, where 3 courtrooms are being used to conduct a trial, and I believe this was a time when only 1 trial could occur at a time, the district court has discretion to keep the case moving along. He's in the best position and in a perfectly reasonable position to determine what logistical hurdles he's going to be injecting in that moment in time if he takes up Mr. Perry's request, whether that's a temporary or a permanent one.
I'm not sure why the need for a continuance or not, and the subject of delay is dispositive anyway. Under these facts, this is again the 6th lawyer, a perfectly appropriate, complete, thorough Ferretta hearing, waiver of counsel, lots of bad behavior by the defendant with respect to his previous 5 lawyers. Why isn't the line of cases that hold that at a certain juncture, this being one of them, where a valid waiver of counsel is taken and the defendant elects to proceed with self-representation, as is his right, he needs to be held to that choice, regardless of whether there would be a delay or not, or whether standby counsel could easily step in or not easily step in. It's just the end of the line.
I take your point, Judge Sykes, and I agree with you. And I think your question speaks to the many permutations that this sort of wavering between counsel and going pro se can take on. The case law, though, is clear that once the trial begins, we're in a different world than we would be in perhaps a month earlier. Regardless of when the trial counsel is faced with this decision, it is reviewed for an abuse of discretion, which means that the decision that the court makes needs to be reasoned and not arbitrary. And so, I mean, there may be circumstances 2 months before trial where there is time and defense counsel is ready or could get ready, where that might be unreasoned or arbitrary.
Why is it unreasoned or arbitrary to say no more lawyers? You've validly waived your right to counsel. We've given you 5 different lawyers. There won't be a 6th. There's nothing arbitrary or unreasonable or
on these
unreasoned
facts, you're
about
absolutely
that.
right. On these facts, you're absolutely right. He's cycled for 3 years through 5 different lawyers. Judge Leinenweber was extraordinarily patient with him and I would say generous in allowing him to go back and forth.
Right.
He had
Because the
informed
constitutional
colloquies.
question depends on whether the Ferretta waiver was valid.
And he knowingly waived his right.
Right, and there's no challenge to the adequacy of that waiver colloquy.
Correct.
So I don't know what more we need.
Correct. You're not hearing disagreement from me, Judge, but this case can also be decided probably on the simpler grounds that he was not wrong to conclude that a continuance would be required to substitute counsel in during the first witness of a complex case that he had presided over for 3 years.
If we focus on the continuance question, what standard should we adopt or apply in determining when a court needs to conduct an inquiry?
If I'm following you, Judge Steve,
So there was no inquiry here.
Right.
What should the standard be that when a district court judge must conduct or should conduct an inquiry into a defendant's basis for saying, I want standby counsel, and whether or not standby counsel is ready to step in?
Well, I think that is a factual finding that's reviewed for clear error. So when Judge Leinenweber says this is going to necessitate a continuance based on the 3-year history of this case. If that's not clearly wrong, there's no need for a colloquy at all. If it's a situation where he can't reasonably draw that conclusion because there's just an absence of facts and data from which to make it, that might be a situation where a colloquy is
So as
necessary
long
to
as
gather more
he
information.
can reasonably, as long as the court can reasonably draw the conclusion based on the record, an inquiry isn't needed, is that?
That's my view, and that's what the Third Circuit said in the Levito case.
I think the Third Circuit was a little bit stronger than that. They said clearly apparent from the record.
Clearly, okay. Well, nevertheless, in that case, it was virtually the same situation. I think it was actually the morning of jury selection. The jury had not been impaneled. Standby counsel had been on the case for a year, and the court said, I can determine based on my vantage point that this is going to require more time. Here you've got an even more extreme situation where not only are we in the middle of the first witness, but standby counsel has said that morning that he's done no significant legal work in the case. That was literally, I think, 6 hours before this issue came before the judge. And so that is a finding that should be reviewed for clear error. It was not clearly erroneous. He had ample reason to draw that conclusion. And to Judge Sykes' point, I think at that point he's vested with the utmost discretion to keep the trial moving and hold him to his knowing and voluntary waiver that he's twice made. So unless the court has any other questions, I'll ask you to affirm the judgment and sentence of the district court. Thank you.
Your Honor, I want to touch on 2 points that the government raised. First, regarding this suggestion that Mr. Lukaski's function up until this point had been purely ministerial, simply because he hasn't performed any substantive legal work for Mr. Perry or hadn't reported that, doesn't mean he's not capable of doing it. In fact, that's one of the chief things that the government cites to as evidence or any kind of evidence in the record that he wasn't prepared. The court told him to be, or advised counsel to be familiar with the facts of the case so he could assist with any kind of substantial legal work, including anything that the defendant might request, both before and at trial. And the court did not inquire as to whether or not the counsel had followed that direction and indeed could perform those functions. As a result,
What's the source of your argument, the legal source of your argument that an inquiry or colloquy was necessary?
Well, there isn't that rule doesn't exist in our circuit. As in the Levito case, the Third Circuit actually does have that rule.
Okay, so you're asking us to create such a rule
Well,
under the authority of what law?
I disagree. I don't think that we're necessarily asking for a blanket rule that any kind of post-waiver withdrawal of the right of that waiver requires an inquiry into it. It's just that the circumstances of this case required an inquiry, specifically since that the reasons why the court gave that they couldn't do an inquiry, there simply isn't any evidence in the record.
But you still have to have a legal basis for the rule that you're suggesting that we apply in this case, which is that under the circumstances here, the Sixth Amendment and or the Due Process Clause, pick your source,
I think it is
constitutional source required a colloquy.
I think it would be the Due Process Clause. I think that at the very least,
And
simply
is there
because
any Supreme Court case that so
I think it's just the
holds?
general. Sorry, apologies. I think it's just the general proposition that in order for the court not to abuse its discretion, in order to exercise its discretion in a reasoned way, there actually has to be a reasonable basis for that finding. Here, there was no reasonable basis for that factual finding because it did not conduct an inquiry into whether counsel required a delay.
So this is not a Sixth Amendment case. This is a due process case.
No, I'm just saying that
Well, I'm asking you the source of law for your argument.
Right. I'm saying that the rule for the specific question as to whether or not what is required for this inquiry and what compels an inquiry in this case. It is a due process issue because the court can't make that finding based on it, but it's one that is linked to, that is based on or flows from this Sixth Amendment right.
Right. So, but you're not arguing that there was a Sixth Amendment violation in this case. To Judge St. Eve's very first question.
No, we are arguing that. It's just as if you had a Fourth
Is
Amendment.
there any case that holds that there's a Sixth Amendment right or a Sixth Amendment duty? The judge has a duty under these circumstances to conduct a colloquy.
No, but I don't.
Another Ferretta inquiry, in other words, or another to reverse Ferretta, I guess, is what it would be in this situation, to unwind the waiver. This is a request that he's making to unwind his previous waiver of his Sixth Amendment right to counsel. Is there any case that says there's a Sixth Amendment duty on the part of the court to conduct that kind of an inquiry?
I don't believe that there's any case in the Seventh Circuit that requires that based on these circumstances, that it
Is
must.
there a case so holding anywhere
Yeah, in the Third Circuit.
as a matter of Sixth Amendment law or due process law?
I don't know off the top of my head whether the rule in.
That's
says-
important.
My understanding is that it's the Sixth Amendment. That's my understanding, but I don't know off the top of my head, Your Honor. I believe that's because it's couched in these terms, that there's this ongoing, just because you waive it, doesn't mean that you completely give up. The Sixth Amendment never applies again.
Well, that's the nature of a waiver,
Right, but
and it
The-
kind of does.
But there are circumstances which I think my understanding at least is that, so I think the way that the rule is couched in the Third Circuit, because it is the failure to make an inquiry into a defendant's request to withdraw that waiver, that there is a due process concern, but it's also that their Sixth Amendment rights, once waived, are not waived forever. They cannot be clawed back under certain circumstances, or they cannot be at least reasserted under certain circumstances. You have a Sixth Amendment right. Attempting to reassert that requires an inquiry as to whether that assertion has been waived such that the court can ignore it and reassert that waiver and trust the waiver was knowing and voluntary, and that this attempt to withdraw it is invalid. That wasn't the case here.
Thank you.
Thank you.
Our thanks to both counsel. The case is taken under advisement. We'll move to our fifth case this morning, Westmoreland versus Hughes. Mr. Morrissey.
May it please the court. My name is Patrick Morrissey, and I am one of the attorneys for the plaintiff appellant, Eugene Westmoreland. The Prison Litigation Reform Act requires prisoners to exhaust remedies that are available. A prisoner follows this duty by adhering to the prison's specific rules and deadlines. When an administrative remedy is not available, a prisoner does not have to exhaust before bringing suit. Mr. Westmoreland was at the Cook County Jail when he initiated the suit against the Illinois Department of Corrections. He's a wheelchair user, and he was waiting to be transferred to the Northern Reception Center. And he alleges the showers at this facility are not compliant with the federal standards. The reception center has 24 housing units. There are 2 showers on the first floor of these housing units. And he alleges none of these showers have seats for a wheelchair user to safely shower. In addition, most of these showers don't even have grab bars to help a wheelchair user. Mr. Westmoreland brought this case for declaratory relief and injunctive relief, individually and on behalf of a putative class. The district court correctly found that when Mr. Westmoreland initiated this case, he did not have any available remedies. Nevertheless, the court erroneously applied the Prison Litigation Reform Act to require that Mr. Westmoreland, despite having Article III standing to bring this case, must wait until he was transferred to the Northern Reception Center, where remedies would there be available, and that he then would have to follow those remedies before bringing this case. This interpretation is incorrect, and it's inconsistent with the text of the Prison Litigation Reform Act and the case law interpreting this statute. The Prison Litigation Reform Act does not require exhaustion of remedies that are unavailable at the time of filing the suit, nor does it impose a duty on a prisoner to delay filing until remedies later become available. On a final point, there's this issue about whether Mr. Westmoreland's claim is moot. This case, the plaintiff moved for class certification and preliminary relief to request the IDOC to establish some type of policy to help people shower that use wheelchairs. And these were filed while Mr. Westmoreland was detained at the Northern Reception Center. The district court correctly...
Mr. Morrissey, what impact should it have here that your client didn't even attempt to exhaust his administrative remedies? I know he's saying they're unavailable, but there's evidence that they do have administrative remedies there. No attempt was even made for us to make that assessment.
That's correct, Your Honor, because when the case was filed, Mr. Westmoreland didn't have any available remedy. The IDOC could have crafted some rule that allows people that are outside their facility to use the grievance procedure. But that rule wasn't set in place by the IDOC.
Is there any case law anywhere that says if you are at a different facility when you want to grieve something and you know you're going to be transferred to another one that you don't have to comply with the exhaustion? That seems to completely undercut the purpose of the PLRA.
Well, Your Honor, if the person was within the IDOC system, I can see how the court's analysis may be appropriate. But Mr. Westmoreland was at the Cook County Jail.
But why wouldn't that undermine the whole purpose of the PLRA, which is to give the institution notice to correct the grievance? He didn't even try to do that.
Well, Your Honor, the law is that prisoners are required to exhaust administrative remedies they're told about, not remedies that they're not told about. They're not required to divine.
Well, he wasn't there yet to know what the administrative remedies were.
That's correct, Your Honor.
It seems like you're trying to get around the requirements of the PLRA by saying he's at a different facility so he doesn't have to, or in the custody of somebody else so he doesn't have to comply with them.
If the Cook County Jail, within their procedures, allowed people to raise these issues and transmitted it to the Illinois Department of Corrections, that would have been an available remedy Mr. Westmoreland could have pursued. But when he
Why didn't he do something once he got to the facility?
Your
Why
Honor,
didn't he attempt to exhaust once he got to the NRC?
The district court asked Mr. Westmoreland that question when the parties had a preliminary injunction hearing, and Mr. Westmoreland didn't provide any answer. He said that there weren't many social workers that came around and that he did not pursue the administrative remedies at the facility.
I think you'd have a stronger argument of unavailability if there had been an attempt in the first place.
And a final note, Your Honor, the issue about the inherent transitory exception would apply in this case if the court determined that Mr. Westmoreland did not have any available administrative remedies at the time this case was brought. The district court correctly determined that this is a situation that it's uncertain that a claim will be live enough for a court to rule on a motion for class certification. And also, there's a constant group of people that have suffered the deprivation complained of. In conclusion, we request that the court reverse the district court's finding and remand.
Thank you.
Thank you, Your Honor.
Mr. Studer?
May it please the court. I'm John Studer on behalf of defendant Applee Hughes. The judgment should be affirmed. Westmoreland filed this lawsuit before he arrived at the center and without even trying to file a grievance, let alone exhaust administrative remedies. This has two implications. One, his case is moot and the inherently transitory exception does not apply. And two, he failed to exhaust administrative remedies as a matter of law. The only ground that Westmoreland raises for reversal is that remedies were not available to him because at the precise moment he filed the lawsuit, he could not yet file a grievance. But he hasn't identified any case that adopts an early filing exception, and the logic of his argument has been squarely rejected by Woodford and this court's opinion in Pozo. He was required to file in the place and at the time required by the department's procedural rules. This brings me to the two grounds that support affirmance. The first is the district court correctly held that the case was moot. It's undisputed that his individual claim was moot because he sought only future-looking relief, and once he was transferred from the center, he could not benefit from a judgment in the case. He tried to save jurisdiction by invoking the inherently transitory exception, but as the district court correctly noted, he was not a suitable class representative given the uniquely strong exhaustion defense as to him, and without a class, the inherently transitory exception does not apply. There would be a second ground for affirmance in that he failed to exhaust as a matter of law. There are no factual disputes about exhaustion here. Everyone agrees that he didn't try to file a grievance, and that the only issue he raises is the purely legal one about remedies being unavailable because he filed before he arrived at the facility.
How could somebody who's being held at the NCR facility ever successfully seek injunctive relief for the shower claim? Because it's a holding facility, my understanding from the record, where they get designated once they're there, so they know they're only going to be there a short amount of time, and the record supports that the average defendant is only there a short amount of time. It doesn't seem like that time is long enough that a claim like this for injunctive relief could ever be successful.
I would not agree that it could never be brought.
And by that, I'm sorry, I mean get thoroughly exhausted so that they could bring it while they're still there.
Well, I think Your Honor is correct that the typical stay at the facility is short. It's about a month to a month and a half, which was the same for Westmoreland. There are some examples of individuals who are at the center for about a year or more. So I wouldn't agree that it's never possible for someone to have fully exhausted and still have Article III standing to bring a claim that's seeking only injunctive relief. To the point that it's more difficult to find a named class representative who has fully exhausted, I would say that they could still exhaust and seek money damages. And as this court has recognized in other contexts, a case seeking money damages has the potential to establish a precedent, and money damages can influence the future conduct of the parties.
But you would agree it would be hard to bring a class based on injunctive relief, given the requirements and the facts of this particular facility?
I think it would be more challenging than an ordinary facility, but I wouldn't agree that there's no such plaintiff that could bring such a case. And I would also point out that there is an emergency grievance procedure. So for things that involve imminent bodily harm or irreparable injury, there's an opportunity to expedite through the grievance process. We don't know what would have happened if he had pursued that here because he just didn't. To a certain extent, we're left to act as seers, which this court has cautioned against. At the end of the day, he made no effort to exhaust administrative remedies, and therefore there's no jurisdiction here. And even if there were, he failed to exhaust as a matter of law. If there are no further questions, we would ask that this court affirm the judgment.
Thank you. Mr. Morrissey.
The district court, on page 10 of its opinion, talks about Mr. Westmoreland being caught in the horns of a dilemma, where he's seeking to obtain relief to help others. It's the defendant's burden to show that there's available administrative remedies to pursue for an individual. In this case, on page 6 of the opening brief, there's an example of people who attempted to file administrative remedies while at the reception center. There's one of these individuals, Florencio Craig, who in fact did file a complaint about the inability to use the shower. He did mark it as an emergency, and it was returned to him as not an emergency. He then had to pursue another grievance where he complained about the exact same thing, and he never received this grievance back until he was transferred to his permanent facility. The record shows that this grievance process at the reception center requires a social worker to receive the document. It then must be provided to the warden. After this grievance is received by the inmate, which may take more than a few weeks, the person then has to send it to Springfield. And the internal rules of the IDOC say that the director may take up to 6 months to address a grievance. the overwhelming majority of the people that stay at this reception center are there for about 24 days. People who use wheelchairs, like Mr. Westmoreland, stay there longer because there are very few places in the IDOC that can accept wheelchair users. That's why he stayed there for 42 days. The defendant has not met its burden that administrative remedies are available for people at the IDOC, and when Mr. Westmoreland initiated this case, there were no administrative remedies available to him to pursue about this precise issue in the prison system. Thank you.
Thank you. Our thanks to all counsel. We'll take the case under advisement and move to our last case this morning, Paz Peraza versus Bondi. Mr. Brzezinski.
Good morning, Your Honors. Budzinski for petitioner de Paz Peraza. Two issues today: whether young male Salvadorans is a cognizable particular social group and whether there is a nexus to this particular social group. Respondent only addresses nexus, so I will spend most of my time there. However, on particular social group, young male Salvadorans is clearly cognizable.
You're not challenging the ruling with respect to the other two social groups, correct?
Correct, Your Honor.
Okay, thank you.
There's no material difference between the particular social group here and the group recognized in CC, young Albanian women living alone. Each of these elements were recognized as immutable characteristics. Additionally, the court may want to address particularity and social distinction. The court previously rejected these requirements, but not since the agency's decisions in MEVG and WGR or since Chevron was overturned. Clarification, I think, would help judges and attorneys given the tension between the prior precedent and the intervening changes. Turning to nexus now, applicants need to show that the harm suffered or that they will suffer was on account of a protected ground. Here again, the protected ground is young male Salvadorans. This is a motive inquiry, but it does not need to be the primary or sole motivation, but only a central reason for the persecution. The immigration judge concluded that MS-13 targeted de Paz Peraza for recruitment because it wanted to fill its ranks with recruits, not because of the particular social group. This is not supported by substantial evidence for three reasons. First, the reasoning is circular, even tautological. Of course, recruitment is filling ranks with recruits. And of course, this is part of what is going on here. But what it fails to consider is that there can be multiple motives and that the particular social group only needs to be a central reason. Second, de Paz Peraza testified that his threats began in high school, that a lot of boys his age or young men were being targeted, that 4 friends told him they received the same threats, that 2 friends were killed, that a neighbor was killed, and that his brother was also threatened. This is circumstantial evidence of the persecutory motive. Third, it's corroborated by country conditions evidence. The Inter-American Commission on Human Rights learned that children are being recruited in schools. Outside the record, the Slate article cited, boys are forcefully recruited while very young for fear they will join rival gangs. And the Criminology and Public Policy article states that MS-13 members are overwhelmingly young males in their teens and 20s. Respondent contends the court cannot consider these articles outside the record. However, the court can and does take judicial notice of country conditions, as noted in Gadai. Relatedly, respondent's contention that a motion to reopen would be more appropriate instead is incorrect. These articles are dated before the agency decisions in this case, meaning there's no changed circumstances here, and this is not evidence that was unavailable. The motion would be denied. Respondent also generally contends that de Paz Peraza presented no evidence that MS-13 knew his age or gender, or even if they were aware, that they were motivated by these characteristics. On the first, they obviously knew his age and gender. Gang members said they knew who he was, and they also attacked and threatened him in person. MS-13 already knew, or they were able to observe, that he is a young male Salvadoran. On the second, as I mentioned, we have de Paz Peraza's own threats, as well as the timing. He was in high school at the time. We also have the threats and harm to his friends, his brother, and other young male Salvadorans. Similar ages, similar timing, the same threats: join the gang or we'll kill you. And again, this is corroborated by the country conditions evidence. MS-13 members are overwhelmingly young males, and they are forcefully recruited while young because of a fear they may join rival gangs. And if there are no further questions, I'll reserve the remainder of my time for rebuttal.
Well, I do have a question. In your appendix at page 6, it looks like it's the oral ruling of the immigration judge, but it has track changes, and it looks reformatted. Who created that?
I believe the immigration judge did that before it, or after it was transcribed, but before it was sent to the Board of Immigration Appeals. I'm not sure when in between his decision and it being transcribed and sent to the Board of Immigration Appeals that occurred, but
And he sent it just like this, you're saying? This is what the immigration judge filed?
I believe so, Your Honor.
Yes, okay. Thank you.
Thank you. Mr. LaForte?
Good morning. May it please the court, Dietz LaFleur on behalf of the respondent. This is a no-nexus case. It's a factual finding reviewed for substantial evidence. It's got a dispositive impact on the disposition of the petition as a whole. You heard petitioner's counsel, one of his last comments he made, that the gang said, "Join the gang or we will kill you." That was the gang's continuous motivation throughout the continuum of this case. In fact, the petitioner says at least 9 times in the record that the gangs targeted him to fill their ranks. In fact, his mother even said on page 366 of the record that, quote, "The gangs wanted to recruit my son." Petitioner's counsel even concedes on page 23 and 24 of his opening brief that he was targeted for recruitment to fill their ranks. That is the only motivation in the entirety of this record. Substantial evidence of the record shows that throughout the continuum of this case, the gangs targeted petitioner solely to fill their ranks and for nothing more. Granados Arias is our roadmap for the disposition of this case. In that particular case, Boisel Vila would be our roadmap. In that particular case, the social group was young Christian group. The court similarly found no nexus because the gang was motivated to recruit the petitioner to fill their ranks. In that case, the court said that the youth group must be at least one central reason. That's key. Petitioner misstated. The standard here is not a reason. Granados Arias and WGR make it clear that the standard here is one central reason. Age and gender have got to be one central reason to implicate the gang's motivation, not a central reason. Addressing petitioner's counsel regarding the Slate article that he seeks this court's judicial notice on. As he conceded, he failed to previously submit this to the administration in the first instance. And he also conceded that if he were to do that in a motion to reopen, it would be denied. Petitioner cites no binding jurisprudence that enables this court to cure that oversight or failure to submit in his evidence package. If the court has no further questions, we ask that you affirm the lower court's no nexus finding and deny the petition.
Thank you. Any rebuttal, Mr. Brzezinski?
Briefly, Your Honors. So the focus on recruitment to fill ranks with recruits, again, I think that's circular and it's a really shallow inquiry into motivation. Why are they recruiting these particular people is I think the question that needs to be looked at. And as the articles pointed out, they're recruiting children because they fear that they're going to be recruited by a rival gang. That's why they're focusing on young boys and young children and young men. If they don't recruit them, they're going to be in a rival gang and they've lost that member. It's not purely because they want to fill their ranks. They aren't going after elderly people. They aren't going after babies. they're going after young men because otherwise a rival gang will make them members and they will not be able to compete.
Thank you. Our thanks to both counsel. The case is taken under advisement, and that concludes the court's calendar for today. The court is in recess.